For today's story, we discuss whether artificial intelligence can get a copyright in the paintings that they produce. Hello, everyone. Welcome to One Civil Law, where we learn through the misfortunes of others. As always, I hope you enjoy this legal education content, and today will be the day that I earn your subscription. For today's story, we're discussing artificial intelligence and copyright. Can the AI get copyright? The AI is starting to replace us all, and it's starting to replace us by making paintings. And this painting, at least in my personal opinion, is somewhat good. So, hey, maybe there's a thing there. But, can the AI get the copyright? Well, the Copyright Board, at least, has said no. So we're going to discuss what the Copyright Board has to say about the issue. And whether or not this becomes a federal court case, we'll see. But let's go through the copyright analysis as it exists right now. First, let's look at the work. This is the work. This is not a copyrighted piece of work because the Copyright Office just said it's not, because it was produced by an AI. And at least to my eye, looks somewhat pretty. I like this painting. So maybe I'll make a print of it and put it on my wall because it's not copyrighted. Let's discuss why. On November the 3rd of 2018, Thaler filed an application to register copyright claim in the work that we saw before. The author of the work was identified as Creativity Machine, which Thaler listed in the claimant along with the transfer statement, ownership of the machine. In his application, Thaler left a note for the office stating the work was autonomously created by a computer algorithm running on the machine, and was seeking to register his computer-generated work as a work for hire to the owner of the machine. In August 12th of 2019, so like a year later, the Copyright Office registration specialist refused to register it, finding it lacks the human authorship necessary to support a claim. Thaler subsequently requested the office reconsider its initial refusal to register the work, arguing that the human authorship requirement is unconstitutional and unsupported by either statute or case law. Well, Mr. Thaler over here has gone for broke. He thinks that the fact that it needs to be authored by a human is unconstitutional, not supported by the statute, and unsupported by case law. All right, let me give you a spoiler. There's quite a lot of case law on point. So there's that. Second, the statute, it talks about authorship, which requires an author. And unconstitutional, you know what? I don't think the AI has First Amendment rights, nor do I think it has rights to copyright registration. Don't think the Constitution was written with the AI in mind. So, no. Thaler does not assert the work was created with contribution from a human author, which would be super helpful. So the only issue before the board is whether, as he argues, the office's human authorship requirement is unconstitutional and unsupported by case law. No. Currently, the office will refuse to register a claim if it determines a human being does not create the work. Well, they talk about the corporations a little bit further on. Basically, corporations can own a copyright, but corporations can't really create a copyright because they're not people. There has to be like a human inventor. So, because it's a work for hire, it can be filed by the corporation, but it still has to be like created by a human. Right. So even in like the case of corporations where like even if Disney is the one filing the copyright, they only have the copyright because a human being created it. Disney can't create things. Only humans can create things. Courts interpreting the Copyright Act, including the Supreme Court, have uniformly linked copyright protection to the creation of human authors. For example, in Burrough-Giles lithography versus Swarney, a copyright defendant argued that photographs could not be protected by copyright because the statute at the time protected certain types of creations of author or authors, and a photograph is not a writing, nor the production of an author, because it's simply a reproduction on paper of the exact features of some natural object or some persons. The court rejected this argument, holding that an author is he whom anything owes its origin, originator, maker, one who completes a work of science or literature, and photographs are representatives of original intellectual conceptions of an author. In the opinion, the court referred to authors as human, describing copyright as the exclusive right of man to the production of his own genius or intellect. So as you can see, a little bit of case law on points. The court has continued to articulate the nexus between human mind and creative expression as a prerequisite for copyright protection. In Miser versus Stein, the court cited Burrell-Gals for the proposition a work must be original, that is, an author's tangible expression of his ideas. And in Goldstein versus California, the court again cited Burrell-Gals for the proposition that while an author may be viewed as an individual who writes an original composition, the term is constitutionally sense has been construed to mean an originator. He who owns anything owns its origin. The office is compelled to follow this precedent, which makes human authorship an essential element of the protection. It sure does. In addition to the Supreme Court precedent, lower courts have repeatedly rejected attempts to extend copyright protections to non-human creatures. For example, the Ninth Circuit held a book containing the words authored by a non-human spiritual being can only gain copyright protection if there is a human selection or arrangement of the relatives of the revelations. So yes, in fact, the Copyright Office has in fact denied copyright to God. If you come with a Copyright Office and say this is a work of God, all of it, yes. It's just literally God, yes. Well, then it's not a work of man, right? So you can't have copyright. So you have to show some sort of human selection or arrangement of revelation in order to get a copyright in that work. So it can't be a pure work of God if you want copyright. So that's kind of funny. The court decisions are reflected in the office's guidance in the compendium, which provides examples of work lacking human authorship, such as photographs taken by a monkey, an application for a song naming the Holy Spirit as its author. Again, not so much if it's purely a work of the divine. While the board is not aware of a United States court that's considered whether artificial intelligence can be the author for copyright purposes, the courts have been consistent in finding that non-human expression is ineligible for copyright protection. Federal agencies have followed the court. In the 1970s, questions about the impact of computing technology on the copyright system led to the creation of the National Commission on New Technology Uses of Copyright Works, CONTU. CONTU's mandate was, in part, to satisfy the creation of new works by application or intervention of automatic systems of machine reproduction. After conducting its review, CONTU determined that existing judicial constraints of original works of authorship, as requiring human authorship, was sufficient to enable protection for works created with the use of computers, and thus no amendment to copyright law is needed. Then there's also a little bit of a footnote here comparing copyright to patent law, which is a very common comparison. You'll see this comparison all the time in the courts. Obviously, there are different statutes, but they're somewhat twinned. And it's very, very, very common to see copyright law read on the patent law and patent law to read on the copyright law. So they take a notice of this patent law decision because there's a footnote here that says, it appears, however, the Eastern District of Virginia has held artificial intelligence systems cannot claim inventorship of patents. They sure did. Thaler versus Hirschfeld. So the same guy tried to get a patent for his computer invention. Now he's trying to get a copyright. The computer invented the thing. So no, you can't do that. The court concluding in 2021, an inventor must be a natural person and upholding refusal of the patent application. Though the court's opinion was obviously based on construction of the Patent Act rather than the Copyright Act, the similarity of the court's statutory analysis to that of copyright cases relied on by the board supports the conclusion, which is perfectly fair because, as I mentioned, the statutes do tend to read on one another, or I guess in this case, constitutional provisions tend to read on one another because they are both provisions of Article 1, Section 8, Clause 8. That's why, by the way. Right, both copyright and patent law derive from the exact same clause of the Constitution, so that's why they're often turned together. The CONTU report mirrors the views of the Copyright Office. A decade before passage of the 1976 Copyright Act, the annual report of the Register of Copyrights considered when copyright protection could vest in expressive works created with a computer. The Register concluded that human authorship was required when the crucial question appears to be whether the work is basically one of human authorship, with the computer merely assisting the instrument, or whether the traditional element of authorship in the work, such as the literary, artistic, or music composition, or elements of selection, arrangement, or so forth, were actually conceived and executed not by man, but rather by a machine. The office's position is supported by a recent report from the U.S. Patent and Trademark Office addressing intellectual property issues raised by AI. The USPTO sought public comment on whether a work produced by an AI algorithm or process without the involvement of a natural person qualifies as a work of authorship under the Copyright Act. In summary of its responses, the USPTO noted the vast majority of commenters acknowledge that existing law does not permit non-human to be an author, and this should remain the law. So the United States Patent and Trademark Office obviously also did their own surveys on this, because the undersecretary, who is the head of the Patent and Trademark Office, is the undersecretary for intellectual property, which includes copyright. So even though the Copyright Office is in it's in a different branch of government, the undersecretary for the Patent Office also advises the executive branch on copyright issues. So that's one of the reasons the USPTO is doing that, even though they don't do the copyright registration, because the head of the office is part of the role. Well, part of his role is to advise the executive branch on copyright policy. So for these reasons stated herein, the Review Board of the United States Copyright Office affirms the refusal to register the copyright. Pursuant to relevant law, this decision constitutes final agency action, which I imagine means this will mature into a lawsuit, which has absolutely no chance of going anywhere. But let's wrap this up. Thus, that brings us to the end of this case about this painting, which I at least think is rather lovely. I think it's a nice painting. I would not object to seeing it. But unfortunately, or fortunately for me, because, it's not copyrighted, so I can show it on screen and also make prints or do whatever the hell else I want with it, is not subject to copyright because it was produced by a computer. The computer has some decent taste, not bad, but unfortunately not a human being. So this work will remain uncopyrighted until, the United States Congress changes the law or something, even assuming they can, because the term authorship also appears in the Constitution, so it might require a constitutional amendment. But before we get too much deeper into the deep weeds of that, at least for a moment, that brings us to the end of consideration of this case. Thank you so much for being part of the Uncivil Law family. If you enjoyed this legal education content, please hit the subscribe button. It really helps the channel grow. We appreciate your continuing support. Until later, my friends, cheers and goodbye.